Hello everyone, welcome to News 18 Explains series. A recent verdict of the Supreme Court on March 20th led to nationwide protests stating that the SC/ST Prevention of Atrocities Act 1989 Act was being diluted. First question is, how was scheduled caste and scheduled tribes identified in India prior to independence?
Well, if you go back, 1931 was the last caste census which enumerated the various castes and communities in India. And on the basis of that, the Britishers identified certain communities which were called depressed classes. And on the basis of that particular 1931 census, a list was drawn, and this was made part of the 1935 Government of India Act,
Right.
in which a separate reservations for these communities in the legislatures as well as in government jobs. And the 35 Act also had provisions for the scheduled tribes. Basically, for scheduled caste, the basic benchmark over the years has been untouchability. For scheduled tribe, I think the basic factor, where the benchmark factor is the isolation.
What does the Constitution of India speak about this?
It is part of the provisions, and once again, it was notified through what is called the 1950 presidential order,
Okay.
in which a particular community is part of that order, which notified as a schedule.
Okay.
And this community is part of that schedule. For example, a Jatav community, say in West and Uttar Pradesh, it fits into the criteria wherein it has over the years and centuries been subjugated to discrimination and untouchability.
One very interesting point is that this particular order, Part 3, had made a categorical distinction between religion, so as to say. So what was it, sir, if you could just tell us a bit?
So there is a provision in that presidential order that only Hindus or scheduled caste or particular community or a person of a community which is prescribed as a scheduled caste by the government notification is entitled to reservations only till the time he or she is Hindu or Sikh or Buddhist. Okay, and if that person suppose converts to Christianity or Islam, then that person would not be entitled to those benefits of positive discrimination. That is probably one of the reasons that we have seen that over the years the maximum conversions of Dalits has been to Buddhism.
Why are there like a parallel central and state OBC lists where there is uniform SC lists?
Because scheduled caste list basically is derived from the presidential law of 1950, which envisages that there is a certain list notified by the government, and any changes, any inclusion or deletion from that list can be done only by an act of parliament, that is an amendment to that particular list by a majority vote in the parliament. But then for the OBC list there is a difference because there are certain communities which may be socially and educationally backward in a particular state, and that may not be the case in the adjoining in other states. Again, recently there was an amendment which was brought into the parliament. Once again, they are making a provision wherein any inclusion or deletion in the name of the central list has to be done by an amendment through parliament.
Okay.
And they say that the central government says that the states will have the freedom to have their own separate list and independence to include or delete any caste. But some state governments have been little apprehensive about it, that their autonomy to include a particular community in the state backward classes list may be hindered.
Where do you see this conflict ending?
The Prevention of Atrocities against SC/ST Act was enacted by Parliament, and it basically had a distinct nature character on two issues. One was that because a majority of it was felt that these weaker sections found it very, very difficult to get the FIR lodged or a complaint lodged with the police if they were subjected to any discrimination or atrocities, which the two-member bench of the Supreme Court had adjudicated. And there was a perception which grew amongst the communities, the Dalit communities, that these provisions have been diluted. The court had basically relied on the data by the NC National Crime Record Bureau on the cases which were filed over the years. But then the counter argument, for example, when we spoke to Ramvilas Paswan the other day, and the counter argument was that if one says that say the conviction rate is low, the complaints are withdrawn. And if that is seen to be a benchmark or an indication that it is being misused. But then suppose there have been massive massacres, huge massacres of Dalits in 90s in Bihar. For example, Lakshmanpur Bate. Okay. 50 people, more than 50 people were killed, butchered. Yeah. Now, the accused in that particular case were convicted by the trial court, but all of them, I think most of them have gone scot-free and have been acquitted by the High Court for the lack of witnesses, whatever. As the Supreme Court has said, even in this case, the conviction has not happened. No. So does that mean that Dalits were not subjected to atrocities? Does that mean that 50 people were not killed in Lakshmanpur Bate? They were killed. But then for various other reasons the conviction has been less. So the court and the government of the day has to go into these reasons